Good afternoon, everyone. It is a pleasure to be joined this afternoon by the Minister of Justice and Attorney General of Canada, Jody Wilson-Raybould, and by accompanying her from the Department of Justice, Lori Wright, who is the Assistant Deputy Minister, Public Law and Legislative Services Sector. Welcome. And Carole Morency, who is back again, Director General and Solicitor General Counsel, Criminal Law Policy Section, Policy Sector. As we begin our study of Bill C-51, an exciting act split into three parts. Minister, the floor is yours, and thank you so much for coming to join us today.
Thank you, Mr. Chair, and thank you to all members of this committee for inviting me to appear again, this time to speak to and discuss Bill C-51, an act to amend the Criminal Code and the Department of Justice Act, and to make consequential amendments to another act. So, as you know, the Prime Minister has mandated me to review the criminal justice system, which is critically important and a long overdue task. As Minister of Justice and Attorney General of Canada, I am committed to making our laws fairer, clearer, more relevant, and more accessible to all Canadians. Bill C-51 reflects that commitment. As I continue to work with the provinces and territories, as well as criminal justice system stakeholders, I am guided by a set of clear objectives. First, using the criminal law to keep Canadians safe and holding offenders to account for their crimes in a just and appropriate way. Second, making sure that our criminal justice system shows compassion and responds to the needs of victims of crime. Third, responding to the needs of vulnerable populations and ensuring that the system does not exacerbate the challenges faced by already marginalized groups. And finally, working to make clearer links between the justice system and other social systems so that we are able to more effectively respond to the root causes of crime. Bill C-51 reflects these objectives through changes that will have a positive and lasting impact on victims of sexual violence. This bill also affirms the fundamental truths upon which our justice system is based, including that the criminal law should be used with restraint, that the state bears the responsibility of proving alleged criminal conduct, and that all criminal law must respect the Charter of Rights and Freedoms. Mr. Chair and members of the committee will already be familiar with the content of the bill. And then in the time available to me, obviously, I don't think I can comprehensively speak to all aspects of the bill. Instead, I will provide a brief overview of the main aspects of the bill and spend the remainder of my time focusing on some key points of discussion that have arisen since I first introduced the bill on June the 6th. It may be useful to think of Bill C-51's proposed amendments as falling into four broad categories. Most of these changes are to the Criminal Code. However, the bill also proposes important improvements to the Department of Justice Act. The first broad set of reforms under the Criminal Code seek to clarify and bolster the laws surrounding sexual assault. Second, Bill C-51 seeks to build on the proposed changes included in Bill C-39, which I introduced on March the 8th, by repealing or amending provisions that have been found unconstitutional by the courts. The third area of reform involves amendments that would remove a number of obsolete or redundant criminal offences. And finally, amendments to the Department of Justice Act would create a new statutory duty for the Minister of Justice to table in Parliament a charter statement for every government bill that sets out the bill's potential effects on rights and freedoms guaranteed in the Charter. So turning first to the sexual assault law reforms, all parliamentarians recognize the importance of taking steps to ensure that the criminal law is as clear and unequivocal as possible in its response to sexual violence. We all know that sexual assault complainants face significant challenges. Therefore, it is absolutely critical that our laws be both clear and clearly understood. This is important for all parties involved in such proceedings: judges, prosecutors, defense counsel, accused, and victims. It is also important for the proper functioning of the system overall. In this respect, the proposed changes clarify that a person cannot consent to sexual activity when they are incapable of doing so, including when they are unconscious. This change is in line with the Supreme Court of Canada decision in J.A. Second, changes would clarify that an accused cannot rely on the defense of mistaken belief and consent if their mistake is a mistake of law or if their belief is based on the complainant's passivity. In this way, it would codify the Supreme Court's decision in Uinchuk. The bill will also fill the gap in law by introducing a specific procedure for determining the admissibility of private records relating to the complainant, such as private journals that are in the hands of the accused. This will complement existing procedures that apply when the accused seeks to obtain records held by persons other than the Crown, for example, a therapist. I pause here to respond to the concerns that have been expressed around these changes. It has been suggested by some that these amendments amount to a codification of a defense disclosure obligation. Mr. Chair, I want to be very clear this is simply not true. These changes provide no rights to the Crown to receive evidence, nor do they mean that the defense would be obligated to hand such evidence over. Rather, the changes concern rules of evidence and seek to balance the rights of the accused and the rights of the complainant, and to support the truth-seeking function of the courts. As was noted in the Supreme Court of Canada decision in Darich, a voir dire held to determine whether evidence of past sexual history is admissible is not disclosure or defense disclosure. Additionally, the bill proposes changes to remove laws that have been found unconstitutional by appellate courts. One example is the proposal to remove the restriction that prevents sentencing courts from giving enhanced credit to persons detained prior to being tried and convicted because they had breached a condition of bail. This was found unconstitutional by the Manitoba Court of Appeal in Bittern. Next, Bill C-51 proposes to repeal 20 different offences that are either redundant of other offences of general application or no longer have relevance in Canada today. Examples include challenging someone to a duel, posting a reward for a return of a stolen item, no questions asked, possessing criminal or crime comics, and publishing a blasphemous libel. These changes are expected to make our laws fairer, clearer, and more relevant and accessible to Canadians. Mr. Chair, I've received a number of letters from Canadians expressing concern about Bill C-51's proposed repeal of Section 176, which appears to offer specific protections to Christian clergymen, and I am grateful to have the opportunity to respond to these concerns now. I want to be clear that removing this offence will not in any way undermine Canadians' ability to practice their religious faith, nor do I expect it to lead to an increase in violence in such situations. Many criminal offences of general application will continue to be available to address all of the conduct that is prohibited by Section 176, and it remains an aggravating factor in sentencing if an offence was motivated by bias, prejudice, hate based on religion. Finally, changes to the Department of Justice Act would require the Minister of Justice to table charter statements that would identify and highlight key charter rights and freedoms that are engaged by any government bill. They would also set out considerations that support the justification of any limits that a bill may have on charter rights or freedom. As members are aware, I have been tabling charter statements for bills that I've introduced since becoming Minister of Justice. We have also begun to expand this practice to bills introduced by other ministers as well. The amendments would entrench this practice in law and extend it to all future government bills. These changes, as well as those proposed to the Criminal Code, reflect our government's unwavering and deep commitment to respecting the Charter. Quite simply, we can never abdicate our responsibility as a government to ensure that our decisions, including those reflected through law reform, comply with our fundamental rights and freedoms. That is why I'm so pleased to sponsor a bill which reinforces the obligation of current and future governments to adhere to this most basic duty. Mr. Chair, I want to thank you again for the opportunity to appear before this committee, and I look forward to all of the questions and discussion.
Thank you very much, Madam Minister. And I also wanted to salute and say hi to Mr. Tabera and Mr. Angus, who are joining our committee today. It's nice to have you gentlemen with us as well. So we're going to do one round of questioning and then general questioning while the Minister is here with us. And we're going to start with Mr. Nicholson.
Well, thank you very much, and thank you for your appearance here today. You'll remember, Minister, that earlier this year there was quite a bit of discussion in Parliament and a number of motions and debate with respect to the protection of people's religious freedom, and with respect to the Charter and the Constitution of Canada. People's right to practice their religion is a fundamental right that Canadians have. So I was surprised when I had a look at the details of this bill that one of the things that it does is removes the specific protection for religious services and members of the clergy. Now, I noticed that at the time it was announced, there was no mention of this. It was just said that there is obsolete, redundant, no longer relevant. I think that most people in this country would agree with me that anybody who disrupts a religious service or threatens or does anything to interrupt anybody's religious service, no matter what it was, that is serious, and it's worthy of the special protection, for special section that it has in the criminal code, that most people, I think, would agree with me that it's not the same as causing a disturbance at an arena or interrupting a meeting. So why don't you agree with me that we could just remove this section here, that in fact that it's still relevant?
Thank you for the question, and I do remember a lot of the discussion that took place back then. In terms of Section 176, as I stated in my opening remarks, there are certainly other provisions in the criminal code offenses of general application that could capture all of the activities that could potentially occur in a religious facility against a religious officiant. Provisions or offenses around causing a disturbance, assault, uttering threats, mischief from property, inciting hatred. I recognize, as you do, that freedom of religion is a fundamental right that's guaranteed under Section 2 of the Charter of Rights and Freedoms, and this bill in no way proposes to make any changes in that regard. I know and am confident that Canadians can continue to practice their religious faith without fear of violence and disturbances, and that is due to the protections in the Charter, due to the provisions or the offences of general application that will capture any activity in the criminal code. It's simply ensuring that we remove provisions that are already accounted for in the criminal code.
I agree with you that somebody could still be charged with mischief, somebody could still be charged with threats and assaults, but I cannot see why the specific protection for people's right to practice their religion or members of the clergy, why this would somehow get on the radar. It wasn't mentioned, if you remember, when the announcement was made. Interestingly enough, just in April of this year, it was reported in the paper that there was an attack in St. Peter's Basilica on Kent Street when someone broke the arm off a statue of Jesus on a crucifix just before an evening mass, and a woman was charged with breach of her judicial rights and disturbing a religious worship in relation to that incident. So this is not obsolete, or it's not something that's not being used. I mean, this is just right here in Ottawa just about 5 or 6 months ago. So I'm going to be bringing an amendment, and I'm hoping that it'll have the support of the members here, to delete the section that will remove remove the special protection there are for religious services. And I would hope that, because there are many great sections that you've got of this bill here, the codification with respect to a number of the areas of sexual assault, and I'm hoping that you'll consider that and agree with me that we should remove the deletion of Section 176.
Well, and thank you for your additional questions. And as I've said, every time I appear, I would welcome any potential amendments that would seek to improve this legislation. I will say, with respect to, and the member likely knows this as well, Section 176 has not been charged very frequently. I'm familiar with the case that he's referencing in terms of what the situation that happened here in Ottawa. Section 176 is difficult to prove. The various elements contained therein. It is limited to individuals or clergymen or ministers in the Christian faith, and it's not inclusive of other religious leaders. And I will say again that and the member has agreed with me, that there are other provisions that will adequately capture all of the activity that potentially could take place.
Let me just ask one more. We'll be following that up. You can imagine the very first section that was deleted, and again, this didn't get any publicity, was the special section that provides, makes it an offense if you in any way threaten or attempt to attack Canada's head of state, the Queen. Wouldn't you think it's maybe bad timing in the 65th anniversary of the Queen's reign that somebody like her, who has an unparalleled public service record among public figures throughout the world, that we would be removing the specific section? And again, I would believe that most people would say, if you get into or rough up somebody somewhere in a bar some night, that is not quite as serious if you attempt to attack the Queen, who's the head of state. As I say, in many countries that would be treated as treason. But why would you find that necessary to remove that one this year?
Well, we've done a comprehensive review of the criminal code, engaged with many academics, conducted roundtables across the country, had working groups in terms of federal, provincial, and territorial ministers that have discussed this. In terms of the redundant provisions, the repealing the offence of alarming Her Majesty under Section 49 is an historic provision. Has its origins in the mid-19th century England. Again, as with other redundant provisions, we're confident that there are other offences within the criminal code that would account for this type of behaviour, whether it be uttering threats or assault.
But I think you would agree that the woman, whenever this bill was put together, that section or something, she is Canada's head of state, and it protects her against any act that's intended or likely to cause bodily harm to Canada's head of state. And again, I believe if you ask, most people will say that is more serious than if you threaten your neighbor. Not that neither of them, of course, are correct to do, but again, I think most people would agree that this raises it to a whole new level, particularly in a day when public security and security of public figures is so critical.
Well, I would perhaps echo the utter respect that I have, that our government has for Her Majesty Queen Elizabeth. I would say that, again, this in no way detracts from the necessary protections and criminal offences articulated that could be relied on. And I could reference other Commonwealth jurisdictions that have also repealed these provisions, such as Australia and New Zealand.
Thank you very much. We're going to move to Ms. Khalid. Ms. Khalid?
Thank you, Chair, and thank you, Minister, for coming in today. Minister, over the past week or so, we've been seeing on social media #MeToo. These are tens and thousands of women that have come out and claimed that they've been sexually assaulted or have experienced sexual harassment. I begrudgingly added my own name to that list of tens of thousands. Can you talk about what kind of impact this will have on those tens of thousands of women for sexual assault and sexual harassment?
Well, thank you for the question, and I am familiar with the hashtag #MeToo campaign, and I would say, and thank you for sharing your lived experience. I would say that it is paramount, and we had members in the House today speak to that campaign. It is critically important for individuals that are victims of sexual violence, of sexual crimes, to come forward. What the intent behind Bill C-51 is with respect to the amendments to the sexual assault provisions and clarifying the law is to do as much as we can to make it easier for victims of crimes to come forward, to share their stories. We know that the statistics say that individuals do not come forward as much as they should. So what we can do in terms of amending the criminal code, that's the intent behind Bill C-51, to clarify the law around consent and to speak to disclosure and evidence with respect to records held by the accused around the complainants, but we're also taking substantive measures, and we've been taking substantive measures from day one as a government to work as hard as we can to ensure that we provide effective resources in terms of victims support and victim services. We've allocated $12 million in that regard in our Victims Fund. We're also committed to ensuring that individuals that sit on our superior courts across the country are provided and can take advantage of the necessary training in terms of recognizing implicit bias, recognizing individuals that come before them and being more just getting the necessary training that they want, and we've also invested substantive other ways, including working with the Minister of Status of Women around a gender-based violence strategy that looks at prevention, that looks to ensure that the criminal justice system is responsive to victims of sexual violence.
Thank you. Part of the debate that arose out of the Me Too campaign was this discussion around what consent is, and Bill C-51 addresses that issue. Can you review what changes are being made to the law of consent, and why do you think these are important?
Absolutely, and thank you for the question. What we're seeking to do in Bill C-51 is to clarify the law around consent, and specifically in terms of the sexual assault amendments relating to where situations where there is no consent. The amendments would make clear that an unconscious person is incapable of consenting, and in a separate paragraph, it would equally make clear that a person may be incapable of consenting for other reasons other than being unconscious. This is activating or putting in place the clarity that was provided by the Supreme Court of Canada in the decision, as I mentioned in my remarks, in JA, and ensuring that just that there's clarity around when consent is obtained and when it's not.
Thank you. And there is another part of that discussion that the accused rights or anybody making an accusation against an individual for sexual assault or sexual harassment, that their rights are somehow being diminished. Can you explain how the rights of the accused were considered in the drafting of this bill?
Well, I mean, again, important question, and we have engaged in substantive consultations and roundtables across the country. We've engaged on a specific roundtable in terms of victims advocates, and recognize in order to have a fairer, just justice system, we have to take into account the accused, victims, and find the right balance. What we sought to do to ensure that there is that balance is to look at fair trial rights for the accused person. We took that into account when we were considering and then when we were drafting the expansion of the rape shield provisions, but also recognizing that we need to respect the privacy rights of the complainant and the interests of justice in terms of the determinations on admissibility. So we took into account a significant number of necessary interest in terms of drafting the provisions that we did.
Thank you, and I just want to say thank you for your efforts in addressing this issue and in all of your work with respect to gender-based violence. You're definitely an inspiration to a lot of people. Thank you.
Thank you.
Thank you very much, Ms. Khalid. Mr. Angus.
Thank you, Mr. Chair. An honor to be here at your committee. And my uncle, who's in your riding, says you're a nice guy. And if my uncle says you're a nice guy, I'm going to say nice things about you. So.
Thank you so much. And thank you to your uncle.
Certainly an honor to have you with us, Madame Raybould-Wilson, and your incredible work as a Justice Minister. And I want to talk mostly today on the issue of the gender lens and how it applies in the Indigenous communities. You have experience in many portfolios, particularly where we're talking with Me Too. It seems to me that this issue of the obligation of the state to prove the alleged criminal conduct of the defendant is a fundamental principle. But when it comes to sexual assault, it always ends up being that the woman seems to have to prove the case herself. And we have situations and issues of sexual assault, the practice of whacking the complainant, as they call it, where it's the credibility of the victim who's put on trial. And we see in the example of the Ghomeshi trial that the question of the violence that he committed was never, ever the issue. The issue was the credibility of the women who were brought forward after the police asked for witnesses to come forward. I don't know if the provisions that you're bringing forward on consent are enough to protect women, to encourage them to come forward, and also to make sure that we maintain a balance of justice in terms of the rights of the defendant. So how are we going to square that circle?
Well, thank you for the question, and I'll say from the outset, it is an incredibly important question, and the objective that you articulated in your question in ensuring that we do everything we can to prevent or to protect victims of sexual assault, to ensure that we provide and create the space as best we can for them to come forward, is an objective that I think everybody around this table shares. We have sought to ensure in Bill C-51 that we clarify the law around consent in the criminal code, that we ensure that that we expand the rape shield provisions, recognizing the twin myths and the ability of an accused to or the ability to introduce evidence that's held in the hands of the accused. Personal records of the complainant certainly can't be introduced for purposes of the proclivity of the complainant in terms of the activity, or that she's less worthy of belief, but that we set in place a procedure to provide a discussion or a voir dire of whether or not those personal records or private records of the complainant should be introduced in terms of procedure. And also the legislation or the proposed legislation provides legal representation to the complainant in these procedures. But beyond what's reflected in Bill C-51, we have a lot of work to do. I'm happy that the government has sought to start doing substantive work in that area.
Well, thank you. I'm pleased you talked about the need to move with effective resources, particularly for those who have a difficulty accessing the system. And I mean, the situation in Indigenous communities of the lack of resources, where we have spent months and months and months, police in our region, trying to get rape shield kits that were not available. So how do you get evidence if you don't have rape shield kits? So none of those cases could go to court. These are the basic resources that the communities that I represent don't have. And I'd like to ask you, the government is only paying for one shelter a year for Indigenous women suffering violence and nothing up in Nunavut. Given the extent and the isolation in communities, if we don't have the resources for women to get out of violent situations, how do we expect that we're going to end the cycle of violence?
Well, again, I think ending the cycle of violence is an objective that we all share. And I hear you and recognize the lifelong advocacy that you have been involved in your remote community and the remote communities that you represent. We have done a number of things. Can we do more? Of course. And are we committed to ensuring we do everything we can to provide those complainants that actually do come forward, because not many of them do in Indigenous communities, as you probably know, that the tools and the mechanisms in order to be able to prove the charge are available, whether that be the rape kits, as you mentioned. We have made contributions in the area of $12 million in terms of our victims fund that provides supports to assist victims of sexual assault. We have a pilot project that's ongoing in Newfoundland.
I guess my concern is when we get to the fundamentals, for example, the child welfare system, the broken foster care system, it is the conduit for girls ending up on the street and boys ending up in gangs. And Tina Fontaine, you named the children who've gone through that system and have been victims of violence. And yet you're in court fighting the Human Rights Tribunal. So your government's put about $1 million fighting in order to end that chronic underfunding. And that underfunding is leading to young women and young boys being put out on the street and ending up in situations of violence. I don't get that. It's why are you not complying so that we can end this chronic denial of basic rights?
Well, the question around sexual assault and supporting victims of sexual assault and sexual violence and crimes, I'm very proud of what our government has done to make inroads with respect to addressing these issues. In our last budget, we committed $100.9 million to a gender-based violence strategy.
Like you're at the Human Rights, you've got the Human Rights Tribunal at federal court over children and the children who are being victimized in the broken foster care system. Why would you put all that money into fighting him in court when you could put that money into ending this systemic discrimination?
Just, Mr. Angus, we've verged far away from C-51, but I'll let the minister answer. We're sort of at the end of your time anyway, so let's let the minister answer.
Well, I mean, the answer is that we are committed to taking without getting into specifics about specific cases, we are committed to ensuring that we provide the necessary supports to children in Indigenous communities. And I am very pleased to be working closely with the Minister of Indigenous Services and the substantive work that she's doing to invest in communities the necessary resources that are required for Indigenous children as not to be different from non-Indigenous children. This is an effort that is not going to be resolved in months or a couple of years, but it's an effort that is going to require all of us to ensure that we support Indigenous communities having the necessary day-to-day resources and to close the gap in Indigenous communities from child welfare to education and health, but to also provide that fundamental pathway for Indigenous communities and nations to rebuild and to be self-determining and ultimately have jurisdiction over these really important issues as communities take advantage of the Prime Minister's commitment to build a nation-to-nation relationship, and this requires all members around, and I know that the Honourable Member would be in agreement and that we need to make this transition and transformation to recognition of rights and reconciliation with Indigenous peoples.
Thank you very much. Mr. McKinnon.
Thank you, Chair. I'm interested in talking about Section 176 as well. Mr. Nicholson asked some very good questions, and I appreciate your answers. Thought they were very good and substantive. But just to go into that just a little bit more, looking at 176 1B, for example, knowing that a clergyman or minister is about to perform, is on his way to perform, or is returning from the performance of any of the duties or functions mentioned in the previous paragraph, assaults or offers any violence to him or arrests him on a civil process or under the pretense of executing a civil process. That's kind of interesting to me because I don't see that, specifically about the civil process business, that the provisions, the protections he might have under hate crimes and other things that you mentioned would give him that kind of protection. Can you please speak about that?
So I'm hoping that I'm understanding your question is different from the question that Mr. Nicholson asked. In terms of 176 and protections that are provided within 176 to clergymen, this is referencing clergymen and not referencing broadly in terms of religious heads. I think that I'm confident that the provisions or the offences of general application will cover the situations and the fact patterns that you've pointed out around provisions in terms of causing a disturbance at or near a public place, assault, uttering threats, mischief of property, inciting hatred against identifiable groups. As mentioned in my remarks, it is an aggravating factor in sentencing where the offense was motivated by hate, bias, or based on religion. And I see repealing Section 176 does not certainly affect the freedom of religion as protected under the Charter, but it provides it removes a provision that is redundant in the criminal code. I think there's, this could be said for other provisions within the criminal code, it speaks to clergymen, it speaks to his calling, it removes the reality of referencing one gender over the other as well.
I mean, I accept all that. I think the language could be broadened to cover all religions and genders and so forth. And I agree with you that there are many provisions in the criminal code and elsewhere to protect in circumstances of violence or intimidation or hate speech and hate crime. But the one interesting thing about this is it kind of establishes a clergyman privilege of not being able to be arrested on a civil offense while they're on the way to performing or on the way from performing one of his regular things. I think it's an interesting thing. I don't know if it's really an important thing, but it's not covered under all those other categories you mentioned.
Well, I hear what you're saying to and from. I honestly do not have a specific answer to provide you with respect to that. I'll look at my officials if they do, but I'm happy to follow up on that specific question.
Thank you. This is Play Stump the Minister today. So maybe we'll just carry on and talk about blasphemous libel, and we're repealing that as an offense. Maybe we could talk more about that and explain how that protects religious freedoms or not.
Thanks for the question, and I was just looking at my notes to see when this offence came in. It has its origins prior to our criminal code here. Its origins come from 17th century England, and it was directed at attacks against Christianity. It has been interpreted as requiring the intention to publish material that, in fact, is likely to shock or outrage the feelings of believing Christians, not other religions. As we have stated earlier in this discussion, the Charter of Rights protects the right to equality, the right of freedom of religion and belief and expression, and this offence does not appropriately reflect those values. This is the other thing that I was looking for. The last reported decision for this offence was in 1936, and England's blasphemy laws were repealed in 2008.
So there are a lot of bizarre and arcane laws here on the books, obviously. I was wondering how you went through and you chose the laws to repeal. I know some of them were cases where they're deemed unconstitutional.
We have, for the past 2 years, and even before that, there have been many commentators, academic, people involved in the criminal justice system that have made commentary around specific provisions in the criminal code. We specifically sought to engage with academics on this issue. We've had over 15 roundtables with criminal justice experts from all different areas around the criminal code. My officials have engaged in substantive working group discussions with our provincial and territorial counterparts to comprehensively review the criminal code. And certainly, as Bill C-39 reflects, eliminating the unconstitutional provisions in the criminal code, and with respect to Bill C-51, looking at the redundant provisions, the archaic provisions, but also looking at where there has been courts have considered, lower courts have considered specific sections, and working to include and remove those provisions.
Thank you very much. Now we're going to move to shorter questions. The minister is still with us for another 17 minutes, so we'll try to make the questions briefer. I know I have Mr. Cooper and Mr. Fraser, and then I'll look for everybody else's hand. Mr. Cooper?
Thank you, Mr. Chair. Thank you, Madam Minister. I certainly note that Bill C-51 does remove certain obsolete sections of the criminal code, and I want to ask a question more broadly about the government's effort to clean up the criminal code. You have stated that it is a priority of the government. Now, 1 year ago, Travis Bader's conviction of 2 counts of second-degree murder of Lyle and Marie McCann of St. Albert, Alberta, was vacated after the trial judge applied an inoperative section of the criminal code, a section that had been found unconstitutional some 25 years later. This committee wrote to you. I held a press conference with Brett McCann in December calling on the government to move forward to remove zombie laws, unconstitutional provisions. To your credit, you did introduce Bill C-39 on March the 8th, and 7 months later, it remains stuck at first reading. What is the delay on Bill C-39?
Well, thank you for the question, and I recognize the members' comments and advocacy, as with the letter that was sent from this committee around the zombie provisions that are in the criminal code. I am fully committed to doing as much as I can to advocate the moving of Bill C-39 through the parliamentary process. I, like you, want to have those provisions, and that's 230 of the criminal code removed, as well as the other unconstitutional provisions that are articulated in 39. Likewise, other bills that I have been and felt very fortunate to introduce around victim fine surcharge. Bill C-39 was phase one of the criminal code cleanup. Bill C-51 is the second phase. I'm hopeful that they all proceed as quickly as possible because I share your concern about having zombie provisions remain in the criminal code and having individuals charged under provisions that have been rendered unconstitutional.
Mr. Fraser?
Thank you very much, Mr. Chair. Thank you so much, Minister, for being here, and to your officials as well. I first of all want to thank you for the effort in putting this bill together, and really appreciated your comments with regard to victims or complainants feeling perhaps more comfortable coming forward as a result of some of the steps that are being taken in this bill. And coming from Nova Scotia, I know there's been certainly a high-profile case and incidents there that are on the public's mind, and that has brought consciousness to this important discussion. In balancing the rights of the accused and victims or complainants, I want to turn to a topic that already had some discussion, and that's regarding the records relevant to the complainant that are in the hands of the defense. As I understand it, there will be a possibility of a hearing before the judge in a voir dire type setting, where a determination will be made on the admissibility of that evidence by the judge. And I think it's good that the complainant would have the ability to have legal representation at such a hearing. I'm wondering, though, if you could touch on how we balance the rights of the accused to a fair trial in the ability of perhaps giving a heads up, if you will, to the complainant about what evidence may be tendered on cross-examination, and perhaps allowing an accused person an ability to tailor evidence based on what normally would be proffered at trial in order to cross-examine the witness.
Well, we've, as we discussed a little earlier, I mean, again, we sought to balance the rights of the accused and recognize the challenges with respect to the complainants and coming forward and do what we can to assist in that regard. Broadening the rape shield provisions around where an accused person has personal records of the complainant. We have, as mentioned, put in place in this particular bill a procedure for the determination of admissibility of evidence. It's not disclosure, it's looking at what type of personal records a judge would determine would be admissible. Certainly nothing that touches on the two or the twin myths in terms of that I mentioned earlier would be admissible, but that we provide the ability to have that voir dire for a judge to make those decisions. We in the legislation are proposing that legal representation be provided to the complainant. I'm pleased that we have, through our Victims Fund, been able to fund pilot projects in Newfoundland that is providing free legal advice in this pilot project to individuals, complainants of sexual assault or sexual violence. We have other pilot projects that are underway as well.
Thank you very much.
I have one more from Mr. Cooper, but just before that, can I see, show of hands, what other members of the committee want to ask a question to the minister? So I'm going to have Mr. Cooper and then Mr. Angus, and then we'll probably be finished the hour. So Mr. Cooper?
Okay, well, thank you, Chair, and I would just reiterate to the minister the urgency in passing Bill C-39. What happened in the McCann case was not unique. It has happened before, and it is just a matter of time before another judge applies in an operative section and another family is victimized like the McCanns. I do want to ask you, however, about Section 176. It isn't unconstitutional. It has been, the constitutionality of it has been upheld by the courts. It isn't obsolete, given the fact that there have been multiple cases in which individuals have been charged and convicted under Section 176. And it isn't redundant in as much as it is the only provision in the criminal code that directly protects individuals to freely practice their religion. Now, in your testimony, You made reference to the fact that that Section 176 applies only in the case of the Christian faith, but Section 176 sub 2 very clearly speaks to disturbing religious worship or certain meetings, and again makes reference to religious worship. So it says nothing about Christianity. I'm not aware of any court that has ever interpreted the section to apply only to the Christian faith. Perhaps you misspoke, or perhaps you could clarify on what basis you stated that Section 176 applies to Christian faith.
Well, again, I'm not going to reiterate the redundancy of 176 and the reasons that I gave earlier, but both of those provisions, A and B, speak to clergymen, and isolating it to what is interpreted as being individuals, clergymen or ministers of the Christian faith, and we do not want to limit it or isolate it to that.
Mr. Angus?
Thank you. I want to continue on the question of ensuring protection in areas of sexual violence, because we deal with victims who are mental health issues, diminished intellectual capacities, where this system simply doesn't work for them. And they get eaten up in the system. And also conversely, many people who end up as defendants who are of a broken background, particularly those who suffered abuse in communities where they grew up and ended up on the street. And the system does not seem to be able to address in a fair manner to ensure justice and protection. Has your department put a lens on these issues of ensuring equity for both the defendants and complainants in cases of violence, in terms of issues of mental health, diminished intellectual capacity, fetal alcohol syndrome, and what steps the justice system needs to be able to adjudicate these issues?
Well, thank you again for the question, and I would love to have this as a long conversation, and I would love to continue to have it with you around the substantive steps that we have taken in terms of the broad comprehensive reform of the criminal justice system. For me, the reality, and this is in terms of the corrections system as well, over approximately 70% of individuals that are in the criminal justice system suffer from mental health issues and addictions, marginalized individuals. There's an absolutely appalling overrepresentation of Indigenous peoples in that system. I am committed through our comprehensive reform of the justice system to ensure that we put justice back into that system, recognizing that we must protect public safety, recognizing we need to respect and support victims of crime, and that we need to uphold the Charter of Rights and Freedoms. I'm looking forward to bringing forward in concert and in collaboration with my counterparts in the provinces and territories, substantive reform to the justice system, of course, to address delays, but also to be very mindful that we need to do better in terms of individuals that find themselves in, whether they're an accused person or a victim of crime, find themselves in the criminal justice system for reasons other than being inherently criminal. I am a strong proponent, when somebody is in the justice system, of finding the necessary off-ramps for that individual, off-ramps that would provide the necessary care, whether that's treatment, whether that is ensuring that we promote sentencing circles and culturally appropriate transitions for Indigenous offenders, as an example, and restorative justice measures across the country is something that I'm absolutely passionate about and hope to and intend to propel further.
Well, thank you. And just a quick follow-up.
One quick follow-up, sure.
I guess the issue then is, I mean, no politicians ever got elected by saying they were going to do justice for people in the criminal system. It requires enormous resources. especially given how overcrowded the court system is, the delays, the difficulties in jails. This would require a major commitment to stop being just tough on crime, but being smart on crime. So what kind of resources are we looking at from the Justice Department to make this happen?
Well, I am working very closely with my counterpart, the Minister of Public Safety. We have and will continue to advocate for the necessary resources in order to achieve the changes that we're seeking in terms of the criminal justice system. Likewise, I've been working very closely, as have my officials, with my counterparts in the provinces and territories, recognizing that the administration of justice is a shared responsibility. I'm very pleased that we have common priorities that we've identified in terms of substantive and bold measures that we can take to reduce delays, and also including preliminary inquiries, mandatory minimum penalties, administration of justice offences, and bail reform. Judicial case management as potential areas that we can look at as well. We've had discussions around the federal, provincial, territorial table on how we can do better to recognize and address and put in the necessary services, and knowing full well that this will require resources to substantively address those individuals that have mental health issues and addictions issues, or have fetal alcohol syndrome, and that we recognize that there's challenges that need to be addressed that isn't necessarily criminal in nature, but that we have to do better as a matter of providing adequate housing for individuals to stay and rehabilitation, transition into the job market. This is a cross-government reality and approach and necessary commitment that our government has made, and I look forward to working with you and all members of this committee as we roll out our broad criminal justice reform.
Thank you.
Thank you very much. And is it fair to say, members, that we can also excuse the officials together with the minister? Or were there separate questions anybody had for the officials? If not, I want to thank you very much, Minister, and I want to thank you both as well, ladies, for coming to accompany the Minister. It is very much appreciated. Colleagues, we're going to have a short recess, and then we're going to resume because we have a couple of in-committee items that'll be very short. So a 5-minute recess, and thank you again.
Thank you very much. Thank you.
you.